Howdy, howdy, howdy. How's it going? What's up? I am back at it reading the Constitution Annotated, Analysis and Interpretation of the U.S. Constitution. Today we are hopping into Intro 4.4. Right now we are in the Introduction-Introductory Materials. Let me go ahead and hop you over to the screen so you can see where we're at. And then we are over here in the Constitution Annotated Methodology section. And we are in the lower court decisions, so it's teaching us how the lower court decisions are handled as far as how they appear in this Constitution Annotated moving forward. So it's just a neat little way of telling us like what to look forward to. So we're working our way through the introductory materials because they wouldn't have put them here if they didn't want us to understand this stuff before moving forward. So I'm giving the government the benefit of the doubt, saying that they want to inform their people, even though I did not read any of this in school. This just now became available in 2019, so hopefully this is now being introduced into some civics curriculum throughout public education. But here we are moving forward to know what we are implicitly consenting to. So now we have Intro 4.4.1, Treatment of Lower Court Decisions Generally. Because the Supreme Court hears only a small percentage of the cases in which its review is sought, and in many cases parties do not seek court review, most litigation over the meaning of the Constitution does not reach the High Court. This leaves many constitutional matters to be decided by the lower federal courts, and in particular, the 13 federal courts of appeal. State courts can also play a significant role in construing the U.S. Constitution and any comparable provisions in the state constitution, while many cases come to the Supreme Court directly from the state courts as state courts of last resort. State courts usually have the last word on the meaning of the state law. Given the statutory requirement to annotate the Supreme Court's constitutional decisions as well as the considerations of space, the Constitution Annotated makes only limited references to lower court decisions as a general rule. Such decisions are not included unless they are particularly influential or address significant issues not addressed by the High Court. Lower court rulings. From time to time, lower court rulings on constitutional law are widely recognized by constitutional scholars to have had lasting influence on interpretations of the Constitution, perhaps even coming to be adopted and relied upon by the Supreme Court. Examples of influential lower court rulings include Judge Lern's opinion on the First Amendment and the incitement of the Masses Publishing Co. v. Patton, and the Judge Frank Easterbrook's opinion on the First Amendment and prohibitions on certain sexually explicit material in American Booksellers Assens. I don't know what ASS apostrophe N Incorporated versus Hudnut. Let's see. Such influential lower court rulings, which may include opinions by future retired Supreme Court justices, are included in Constitution Annotated. Neat. Subjects lacking Supreme Court coverage. In cases where the Supreme Court has not spoken on the precise issue, but a lower court has, relevant lower court decisions may be included in the Constitution Annotated. For example, the Supreme Court has rarely interpreted the Third Amendment. Accordingly, the Constitution Annotated discussion on the Constitution's prohibition on the quartering soldiers notes as a prominent lower court ruling on the issue. Discussion of such gap-filling lower court opinions is intended to elucidate issues that the Supreme Court has not addressed, but is circumscribed and included only for the purposes of noting open questions and apparent limitations in the Supreme Court's current doctrine. Neato! Now, we got our big chunk for this video. This video's got a big old chunky chunk. Non-judicial sources of constitutional meaning. The judiciary is not the only branch of government with a role of interpreting the Constitution. Since the nation's founding, the legislative and executive branches, through their respective officers, have continuously participated in construing the Constitution in both formal and informal ways, providing a rich history that informs modern interpretations of the Constitution. In addition, various non-governmental actors, from academic legal scholars to ordinary citizens, have at times played a pivotal role in interpreting the Constitution and basic norms that underlie it. Interpretations of the Constitution outside of the courts occur in three primary contexts. First, non-judicial actors may opine on the meaning of the Constitution with respect to matters that could be or would have been subject to judicial review. For example, in the wake of the court's 1989 decision Texas v. Johnson, holding that a Texas law criminalizing the burning of a U.S. flag violated the First Amendment, Congress enacted a similar federal law, functionally voicing its disagreement with the court's interpretation of the First Amendment in Johnson. Second, non-judicial constitutional interpretations may occur in contexts that are not generally subject to judicial review. Court-made doctrines, like the political question doctrine and the constitutional standing doctrine, can result in entire provisions of the Constitution being interpreted solely by the political branches and non-governmental actors. For example, the court has held that the propriety of the Senate trial of impeachment is a political question that cannot be resolved by the federal court. As a result, questions regarding the limits of the power to try impeachments are heavily influenced by both long-standing practices of the Senate as well as new developments that prompt changes in such practices. Third and finally, non-judicial interpretations of the Constitution may occur in areas while not wholly immune from judicial review, the judiciary has tended to defer to the political branches. Presidential authority over foreign affairs is an example of such a field. Because nearly infinite understandings of the Constitution exist outside of formal court opinions, the use of non-judicial sources in Constitution Annotated must be limited in some way, in part, to ensure that the focus of the Constitution Annotated remains upon the Supreme Court decisions noted in the statutory mandate. In the interest of balancing these concerns, the Constitution Annotated generally limits its uses of non-judicial sources to situations where 1. The interpretation has no role or a very limited role in constitutional construction, or 2. The judicial actors provide an important interstitial role in informing the general understanding of specific constitutional provisions. Examples of such topics include president's pardon decisions, president's proposing national legislation, president's vetoes in legislation, indeed the deliberations of members of Congress over the standards for impeachment and removal, representatives and senators' votes for and against legislation, and presidents negotiating treaties, senators determining whether to ratify treaties, president's standards for nominations, senators' determinations of the standards for the confirmation, president's standards for removing executive officials, the Congress standards for approving international agreements made by means of other than treaties, and the president's under enforcement of federal laws and executive orders. The Congress's decisions on how to discipline its own members for their misconduct in office, and the uses of military forces without declarations of war. The Constitution Annotated also uses non-judicial sources to supply relevant factual information that the court may have omitted from its decision, but is arguably key to understanding the decision. Also, on occasion, the Constitution Annotated notes that a debate about particular constitutional provision or Supreme Court precedent exists, and cites secondary sources evidencing the existence of such a debate. Ha ha ha! With respect to non-judicial sources, to use the Constitution Annotated concentrates upon sources that are influential to decision makers in the field. or are widely regarded as authoritative or influential within the legal profession, some non-judicial interpretations of the Constitution can influence the actions of decision makers and accordingly are worth citing in the Constitution Annotated despite their advocacy of particular points of view because of their effects on how particular provisions of the Constitution are implemented in practice. For example, the Department of Justice's Office of Legal Counsel, OLC, opinions on the Recess Appointments Clause were discussed and relied on by the Supreme Court in NRLRB v. Noel Canning, demonstrating the influence of that legal office's determination on constitutional law. Examples of such influential sources beyond opinions by the OLC include legal decisions by the Government Accountability Office. In other cases, there is near consensus within the legal profession, including in the justices on the Supreme Court, that certain non-judicial sources are influential and or authoritative on particular issues. Often these sources are ones that have long affected constitutional interpretations, such as Sir William Blackstone's commentaries on the laws of England, the Federalist Papers, and Justice Joseph Story's commentaries on the Constitution. Then Professor Lewis's Brandeis' early writings on the right to privacy, Professor James Bradley Thayer's works on the nature of judicial review, and then private practitioner Learned Hand's writings on economic due process rights. Lovely, lovely, jubbly. Lovely, 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 jubbly. I love you long time and you come back to see me. Love you long time, come back to see me. That's not racist, that's just a ditty. I'm sorry. I love you long time. Goodbye.